Okay, this is our AI case brief. My name is Arieana Castellanos.
My name is Mariana Barcenas, and we are presenting the Thomas Reuters Enterprise Center GmbH versus Ross Intelligence Inc. and the original holding vacated in part by the original judge. And we are citing these cases.
So, summary of the facts. Ross, a new competitor to Westlaw, made a legal research search engine that used artificial intelligence. To train its AI search tool, Ross needed a database of legal questions and answers. So Ross asked to license Westlaw's content, but because Ross was its competitor, Reuters refused. Ross made a deal with Legalese to get training data in the form of bulk memos. Bulk memos are lawyers' compilations of legal questions with good and bad answers. Legalese gave those lawyers a guide explaining how to create those questions using Westlaw headnotes, while clarifying that the lawyers should not just copy and paste headnotes directly into the questions. Legalese sold Ross roughly 25,000 bulk memos, which Ross used to train its AI search tool. In other words, Ross built its competing product using Legalese bulk memos, which in turn were built from Westlaw's headnotes. When Thomson Reuters found out, it sued Ross for copyright infringement.
In summary of the facts, the dispute boils down to whether Legalese bulk memos questions copied Reuters' Westlaw headnotes, or if they were instead taken from the uncopyrightable judicial notes. In 2023, the judge largely denied Reuters' motion for summary judgment on copyright infringement in the fair use defense, and the case moved ahead towards trial. In the run-up to August 2024 trial date, the same judge studied the case materials more closely and realized that the prior summary judgment ruling had not gone far enough. So then the judge continued the trial and invited the parties to renew their summary judgment briefing. So Reuters once again moved for partial summary judgment on the direct copyright infringement and related offenses, while Ross moved for summary judgment on Reuters' copyrights claims. And both sides moved again for summary judgment on fair use, and the judge revised parts of the 2023 summary judgment opinion.
So in the court's original ruling, from the district court, Stefanos Vivas, circuit judge, sitting by designation, held that the genuine issue of material fact for number one between Ross and Reuters. So in this case, a genuine issue of material fact is a disagreement between opposing parties on facts legally relevant to a claim. There was a disagreement between Ross and Reuters over the strength and extent of Reuters' copyright over the material used to train Legalese, which trained Ross's AI, precluded summary judgment for them on the copyright infringement claims. Precluded summary judgment for them means that the court decided not to grant a summary judgment in favor of Reuters because there was a genuine dispute over material facts that needed to be decided at trial, preventing the case from being resolved without a full hearing. The second point, there is a disagreement between Ross and Reuters over Ross's knowledge of and contribution to alleged copyright infringement by Legalese. This precluded summary judgment for Reuters on contributory claims against Ross. Contributory infringement is a form of secondary liability for direct infringement of a patent, copyright, or trademark. It is a means by which Legalese may be held liable for infringement, even though they did not actually engage in infringing activities. The third point, disagreement between Ross and Reuters over Ross's ability to control Legalese precluded summary judgment for Reuters on claims against Ross based on the theory of vicarious liability. This theory holds a party responsible for the actions of another party for Legalese's alleged infringement. There is a disagreement between Ross and Reuters over the kind of Ross's alleged infringing use and to what degree of copyright protection for the works Reuters is claiming was infringed upon applies in this suit.
The continuation portion of the original ruling is that for the fifth part, the copyright generally it preempts tortious interference claims when there is a basis of the interference claim is essentially equivalent to a copyright infringement claim, meaning that if the alleged tortious interference involves unauthorized copying or distribution of copyrightable material, the state law claim is likely preempted by federal copyright law. The preemption doctrine is a legal theory that allows a higher level of government to override a lower level of government's laws. And applying that to the fifth part of the ruling, the Copyright Act did override Reuters' tortious interference claim to the extent that that claim rested on Legalese's alleged violation of anti-competition contract provisions in its license for the use of Reuters' legal research platform Westlaw and Legalisa's platform. The second part of that ruling was that the Copyright Act did not overwrite Reuters' tortious interference claim to the extent the claim rested on Legalisa's alleged violation of the provisions in its license. That provision is for use of Reuters' legal research platform Westlaw and did not allow for automated scraping of content from Westlaw and did not allow password sharing. And the last part was that Reuters established two of the five elements for tortious interference based on Legal East's alleged violation of the license provisions. However, both of the parties disagreed over the three elements of tortious interference and precluded summary judgment. Here, the tortious interference is a legal claim that occurs when someone intentionally damages another person's business or contractual relationships. It is also known as intentional interference with contractual relations.
So to continue the court's updated ruling, for the first part, the partial summary judgment for Reuters on the direct copyright infringement. Copyright validity is a question of law, not fact, making it suitable for summary judgment. Thomson Reuters has copyright registration for Westlaw's copyrightable content, so it has a valid compilation copyright. But if Reuters chooses to try this case based on a theory of infringement of individual headnotes as individual works, rather than infringement of the compilation as a whole, there is still a factual dispute about which individual headnotes are both within the period covered by Reuters registrations and not in the public domain. So if Reuters advances a theory of damages that depends on the infringement of specific headnotes, this evidentiary matter must be taken up at trial. The originality threshold is extremely low, requiring only some minimal degree of creativity and some creative spark. The key question then is whether a work is original, not how much effort went into developing it. So the judge revised those parts of their prior opinion. The headnotes are original. A headnote is a short key point of law chiseled out of a lengthy judicial opinion. The text of judicial opinions is not copyrightable, and even if it were, Reuters would not get that copyright because it did not write the opinions. But a headnote can introduce creativity by distilling, synthesizing, or explaining part of an opinion, and thus be copyrightable. The judge granted summary judgment for Reuters on whether the headnotes and the key number system are original enough to prevent Ross from rebutting any presumption of validity. For the second part, the single most important factor in deciding whether the fair use defense protects a copyright infringement defendant is how the defendant's use affected the copyrighted work's value or potential market. Fair use is an affirmative defense, so Ross bears the burden of proof. The judge must consider at least four fair use factors: the use's purpose and character, including whether it's commercial or nonprofit, the copyrighted work's nature, how much of the work was used, and how substantial a part of it was relative to the copyrighted work's whole, and how Ross's use affected the copyrighted work's value or potential market. Factor 4 in this case matters more. Weighing them all together, granting summary judgment for Reuters, even taking all factors in favor of Ross, it meant to compete with the Westlaw by developing a market substitute. And it does not matter whether Reuters has used the data to train its own legal research tools. The effect on a potential market for AI training has not put forward enough facts to show that these markets do not exist and would not be affected, nor does a possible benefit to the public save Ross. Yes, there is a public interest in accessing the law, but legal opinions are freely available, and the public's interest in the subject matter alone is not enough. Factor 1 is the purpose and character of Ross's use. If Ross and Thomson Reuters use copyrighted material like the headnotes for very similar purposes, and Ross's use is commercial, this factor likely disfavors fair use. First and foremost, those cases are all about copying computer code. This case is not. Though Ross did computer programming, the material it allegedly copied from Thomson Reuters was not computer code. In copyright, computer programs differ from books, films, and many other literary works in that such programs almost always serve functional purposes. So the fair use considerations for these programs do not always apply to cases about copying written words. This was a place where the judge came to the realization about the original ruling that allowed vacating some of the previous holding. So here, fair use is a question for the judge, not the jury. The judge ruled Thomson Reuters prevails on the two most important and the overall balancing end.
The third part of that holding was that there is nothing that Reuters created that Ross could not have created for itself or hired legalese to create for it without infringing Reuters' copyrights. In this case, one of the factors for denying for denying Ross's motion for summary judgment on fair use would be how Ross's use affected the copyrighted work value or potential market. The original market is obvious, that being the legal research platforms. Even taking all effects in favor of Ross, it meant to compete with the Westlaw by developing a market substitute. And it does not matter whether Reuters has used the data to train its own legal research tools. The effect on the potential market for AI training data is enough. Ross bears the burden of proof. It has not put forward enough facts to show that these markets do not exist and would not be affected. The fourth part would be that the first innocent infringement does not apply. Ross claims that any infringement was innocent. As the parties agreed, innocent infringement does not limit liability, just damages. But this limit does not apply when the infringed work bears a copyright notice, as Westlaw's head notes do. Secondly, a copyright misuse does not apply either. Ross claims that Reuters misuses copyright. Copyright misuse is a defense when copyright holder weaponizes a copyright against the public interest, typically for anti-competitive behavior. But the judge already ruled at summary judgment on Ross's antitrust counterclaims. Ross has not shown that Reuters may use his copyrights to stifle competition. Third, the merger defense is inept. Ross claims that any ideas were so close to the expression that they merged with the expression, making it uncopyrightable. But there were many ways to express points of law from judicial opinions. Fourth, the scene's a fair defense does not fit. The defense covers stock elements that follow from works nature, like historical romance novels, damsel in distress, but nothing about judicial opinion requires it to be slimmed down to Reuters' head notes or categorized by the key numbers.
So the court's updated ruling, the judge granted partial summary judgment to Thomson Reuters on direct copyright infringement for the headnotes in Appendix A. For those headnotes, the only remaining factual issue on liability is that some of those copyrights may have expired or been untimely created. This factual question underlying copyright validity is for the jury. The judge also granted summary judgment to Reuters against Ross's defenses of innocent infringement, copyright misuse, merger, scenes of fair, and fair use. The judge denied Ross's motions for summary judgment on copyright infringement, direct copyright infringement, and fair use. The judge revised all parts of the prior opinions that conflict with this one. The judge also left undisturbed the parts of the prior opinion not addressed in this one, such as rulings on contributory liability, vicarious liability, and tortious interference with the contract.
The significance of this case is that Ross built his competing product using Legal Ease's bulk memos, which in turn were built from the Westlaw head notes. And then when Reuters found out, it sued Ross for copyright infringement. The court ruled to grant partial summary judgments on some elements in favor of Reuters and left some elements of the copyright to be decided by the jury. Set a precedent regarding how information scraped from legal research platforms can and cannot be used in accordance to the Copyright Act and existing licenses and contracts. Further, it also set a precedent regarding what does and does not constitute computer programming and code when information is used to train AI models, regardless of whether there is an existing market for those or not. And that concludes our presentation. Thank you.
Thanks, everyone.